Okay, well, my watch says it's 3 past the hour, so this is usually when we start to jump in. So thank you all for joining us. We're really excited to have you with us. I'm Pam Metzger. I'm the director of the Decent Criminal Justice Reform Center at SMU Law School. And for those of you who may not be familiar with our work, we are an interdisciplinary research center, and we focus primarily on the right to counsel at the earliest stages. We also do some work on prosecutorial charging discretion, and a great deal of our work centers on the operation of criminal legal systems in small, tribal, and rural communities. And in those communities, again, we primarily focus on access to counsel and timelines for prosecutorial decision making. This is part of a monthly series we do where we bring in scholars at all different stages of their careers to talk about work in progress. Any of you who are joining us today who have an interest in presenting works, please don't hesitate to email and let us know. We'll have some contact information for Divya Lal, who's on our staff, who organizes these. Again, if you have an interest in presenting your work, please let us know. It is my very great pleasure today to introduce our speakers, and I'm really looking forward to this conversation. It's a topic near and dear to my heart. Doctors Don Stemen and David Olson are both professors of criminal justice and criminology at Loyola University of Chicago. They're also the co-directors of Loyola's Interdisciplinary Center for Criminal Justice. They both have decades of experience conducting research and evaluating criminal justice policies. And importantly, they do this work in collaboration with practitioners in the criminal justice system, with policymakers, and with stakeholder organizations. Their center's goal is to provide objective and rigorous research that is going to inform the development, implementation, and evaluation of criminal justice policies and practices. Today, I am very excited. They're going to be talking about their research examining the implementation and development and impact of Illinois' Pretrial Fairness Act, the PFA, which abolished the use of cash bail in Illinois, restricted what kinds of cases would be eligible for pretrial detention, and also requires more deliberative hearings, including the right to counsel, when detention or more than minimal conditions of pretrial release are sought. I've had the advantage of getting a little sneak preview of some of this work at earlier conferences. It is fascinating and important, and I am thrilled to hand it over to them. Our plan is to have them present to us for maybe 15, 20 minutes. We will then open it up to the group to ask questions. Please, if you have a question, you feel free to raise your hand, but you can also put it into the chat, and we'll be checking in on the chat and for questions as well. So with that, I think, Dave, you're going to take us to the conversation.
Yeah, thanks everybody for taking the time to be here. The screen, what I want the screen to look like, Don? Okay. All right. So again, thanks to SMU's Decent Center for inviting us. We're going to try to provide you with a summary of now 4 years of research we've been doing on this topic in 15 to 20 minutes. So it's going to be fairly general, but I think we're going to highlight some points and some findings that will be of interest to folks. So Don and I are going to kind of trade off what we each talk about. What I will start with, if I can advance the screen, is just really briefly the methodology and how we're approaching this evaluation. And this will not be a research methods course. It's just to give you a sense of what we're trying to do. The evaluation is designed to be done over the course of 4 years. We've got a grant from the National Institute of Justice, as well as a number of foundations to support the research. We're approaching this from a multi-methods perspective. So we're doing a lot of work to understand the implementation and impact of the policy from a lot of different dimensions. So we are doing surveys and interviews and focus groups with practitioners that are involved in carrying out the law. We're observing the court hearings, and we're analyzing a lot of administrative data that we're collecting from agencies. Importantly, the design is set up to be a pre-post design. So we started to do this work 2 years before the law was actually implemented to establish kind of a Pretrial Fairness Act baseline of what was going on, and then have continued those observations and interviews and data collection efforts. To evaluate the program or the policy appropriately, it requires a lot of detailed data. Currently in Illinois, there is no single central repository for all of the data that's needed. So we decided that we needed to focus on specific counties where we would go directly to those counties and collect the types of data that were needed. So the counties on the map are the counties that are part of our research study. For those of you not familiar with Illinois, Chicago or Cook County is up in northeastern Illinois. And then you see the counties spread across the state. The counties were selected primarily because they represented the different types of environments within which this law is being implemented. So it's Chicago, it's the suburban counties around there, rural counties, and then urban areas outside of the Chicagoland area. So we really wanted to make sure that we studied it in a lot of different settings. The other thing about the law, just to understand its implementation, is this is a state law, but it's being implemented in each of Illinois' 102 counties. So each of Illinois' 102 counties has a separately elected state's attorney, separately elected judges, and public defense, for the most part, is organized and supported at the county level. So what you're going to see, kind of skipping ahead to our conclusions, is there's a lot of variation from county to county in what we're seeing. And some of it is because of the nature and size of the county. For example, rural counties versus urban counties. As Pam mentioned, we collaborate with stakeholders. For this project, obviously, we're working with all the elected and appointed officials in the counties where we're studying the law. But there's a couple state agencies that we're also collaborating with. The Illinois Department of Corrections Jail and Detention Standards Unit is providing us with some data on jail use and jail populations. And then the Office of Statewide Pretrial Services is a new agency in Illinois. It was created in 2022, but we're working in collaboration with them because of the types of data that they're able to collect. And we'll also be talking a bit more about kind of the impact of their office on the implementation of the law. So I'll switch it over to Don, and he'll cover some of the aspects of the law.
Thanks, everyone. Hi, my name is Don Stemen. I'm a professor at Loyola and co-direct the Center for Criminal Justice with Dave. The first big takeaway, when we think about the impact of the Pretrial Fairness Act, the one thing we want to make sure we emphasize is, and the headline that most people think about when they think about the Pretrial Fairness Act, is the complete elimination of cash bail in Illinois. Right, it's the first state to completely eliminate the use of cash bail as a release mechanism pre-trial. And when we think about that impact, before the Pretrial Fairness Act went into effect, Illinois collected about $140 million a year in bail from defendants and their families. Most of that money that was collected was not returned to defendants, but was distributed for fees, fines, restitution. And defendants and their families got very little of that back. So the one impact we want to make sure we emphasize is defendants no longer have to pay cash bail to be released from jail pre-trial. The other thing, and think about that impact and what it has for counties, 10% of all bail collected by counties was kept by the county as an administrative fee. So about $14 million a year was kept by the counties. That was regardless of the outcome of the case. So there is a secondary impact on local criminal justice systems where they're no longer collecting administrative fees that they were collecting on cash bail. But the impact of the PFA goes beyond that. Dave, you can go to the next slide. It also changed the hearing process for determining whether or not a defendant would be detained pre-trial. Hearings were meant to be more substantive, more deliberate. They were supposed to take longer when the decision to detain someone pre-trial was being made. And it requires that defendants have legal representation at all pre-trial hearings. So prior to, and we'll see in a couple slides, prior to the Pretrial Fairness Act, there were many instances, particularly in rural counties, when defendants were not being represented at bail hearings. After the PFA, they're now required to have representation at all hearings. So when we think about what that substantive hearing looks like, you can go to the next one, Dave. Prior to the PFA, when we think about what factors were being considered, this is based on court observations that we did primarily in Cook County. But when we think about what was happening before the Pretrial Fairness Act went into effect, you can see that there's very little overlap in what defense counsel, prosecutors, and judges were using to make decisions. Prosecutors were primarily relying on the current charge that the defendant was charged with, prior convictions and victim information. Defense attorneys were primarily relying on factors related to employment and community ties, and judges were rarely providing reasons for why they were making decisions. When they did, they tended to be around risk assessment and the prior convictions. So then what we were seeing in these pretrial hearings too, when when bail was being decided, hearings took 3 to 4 minutes for this decision to be made. After the Pretrial Fairness Act, though, things have changed quite considerably. There you go. What you see is more diversity in the factors that are being discussed, both by prosecutors, defense, and judges. What you're seeing is more overlap in the factors that are being considered by the different parties. There's more discussion of the strength of evidence involved in the case. What's happening now at these pretrial detention hearings is a decision is being made around the strength of the evidence and whether the case can continue. So you're seeing arguments around that. And what you're seeing is judges providing reasons for the decisions that they're making. As I said before, prior to the Pretrial Fairness Act, judges rarely provided reasons for why they imposed bail. And what you're seeing now is a much more deliberative, substantive process with judges now providing reasons for why they're detaining individuals or not detaining individuals. What's also happened is we said there's now a requirement that defendants have an attorney present at all pretrial conditions and detention hearings. Now, in urban counties, this was happening in almost all cases already. Most of the urban counties in the state had pretrial or public defender services. They staffed detention and bail hearings 6 days a week. In rural counties, though, what we heard from practitioners and what's borne out by the data was that defendants rarely had counsel at pretrial hearings before the Pretrial Fairness Act. In many counties, in rural parts of the state, they have part-time defender services. So defense attorneys were only available to defendants 2 days a week. And if a bail hearing didn't happen on one of those 2 days, they didn't get counsel. So what you can see is after the pretrial fairness, a significant change in this. So you can see in those counties that had part-time public defender services before the Pretrial Fairness Act, about 30% of defendants had an attorney present at these pretrial detention hearings or bail hearings. After the PFA, that's increased to almost 100%. Even in those counties that had full-time public defender programs, only about 70% of defendants had an attorney present in initial bail hearings. Now, after the Pretrial Fairness Act, you can see that's jumped to almost 100%. So we can see a shift both in the substantive content of the hearings, but also the presence of counsel at those hearings. It's important to note, too, that the state has appropriated about $10 million in counties, not Cook County, to try to make sure that there's more robust public defense going on in the state. So we have yet to see exactly how that's going to pan out, but we know that the state is starting to provide those services and public defense work across the state in an effort to try to increase the ability for defendants to get counsel. And I'm going to turn it back over to Dave now to talk a little bit about what those outcomes of those hearings look like.
All right, thanks, Don. So going to talk a little bit about the process by which individuals are detained and what the outcomes of those efforts look like. So a little bit just for context, so folks who aren't familiar with the law, what the law does is it identifies specific crimes that are eligible for pretrial detention. So an individual has to be charged with one of these specific offenses that's where detention is allowable. For the most part, the cases that are occurring are people who are being petitioned for detention because they pose a risk to public safety. There is another category of crimes that's a bit broader where an individual could be detained if the prosecution feels and can convince a judge that the defendant poses a risk of willful flight from prosecution. In the observations we've been doing of hearings, we have not seen any cases where the articulated goal of pretrial detention is to prevent willful flight. So it's really focused on issues around public safety and the offenses that are eligible for detention under that category. Just to give you an understanding, it includes domestic battery offenses, whether it's a misdemeanor or a felony. It includes illegal possession of a loaded firearm in public if you do not have a concealed carry permit. It includes forcible felonies, and then it also includes any offense that carries a mandatory prison sentence, even if it's, for example, a drug law violation that carries a mandatory prison sentence or a residential burglary offense. So the law restricts which offenses can be considered for detention. It also establishes a process where the state's attorney in the county has to initiate the request for detention. So if they want to seek detention, the individual is to be charged with an eligible offense. They then file a petition to detain, and if a judge determines that the person has in fact been charged with a detainable offense, they will have a hearing. Right? Those hearings, as Don described, are much more substantive and involves legal representation. They're much longer than what was occurring when bond was being considered. But ultimately, the decision at that hearing as to whether or not the person should be detained is based on a judicial determination. The judge has to evaluate the strength of the evidence and the likelihood that the individual had committed the offense. It also has to determine the dangerousness to the community. And lastly, it has to ensure, the judge has to articulate why pretrial detention is the only option available as opposed to pretrial release with supervision or with electronic monitoring or something like that. Right, so there's a couple different ways that we've gone about looking at this process. What you're seeing on the screen is basically a summary of what happened to people who were charged with offenses that were eligible for pretrial detention. On the left, you see the outcomes of those cases that originated in Cook County, which is Chicago. And the way to interpret this is out of all the people charged with a detainable crime under the public safety consideration, 69% of those defendants or those cases did not involve a petition to detain. So the state's attorney did not seek to detain the individual, which leaves 31% of the cases where a detention petition was filed. Overall, in Cook County, about 18% of people charged with a detainable offense were actually detained pre-trial. The bar on the right is what the pattern looks like in the rest of Illinois. And the obvious difference is outside of Cook County, the majority of defendants charged with detainable offenses are in fact petitioned for detention. And because of that higher rate of detention being sought, the net result is about 34% of all defendants charged with a detainable offense are in fact being detained following the detention hearing. Right? So this provides you with some understanding that what was going on in Cook County or Chicago looked different than the rest of Illinois. But as I pointed out, this policy is carried out across each individual county. Don't try to analyze too much detail in this slide. It's really just to it's to help you understand the variation across the state. When you look at each county, in what percent of eligible cases is the state's attorney filing a petition for detention? And so you can see that there's some counties where more than 60% of defendants charged with a detainable offense are having detention sought. And then there's counties where 30% or fewer of the defendants charged with a detainable offense are having detention sought. One of the important things from the research that we've been doing is we're trying to examine what are the factors that predict whether or not a defendant will have a petition to detain filed, because that really is the starting point that cascades to ultimate detention. What we're finding is there are certain characteristics that you would expect, things like the seriousness of the crime, the extent and nature of the defendant's criminal history, if they were on supervision already for another offense. But importantly, even after you account for those differences, there's still a lot of variation from county to county in the rate at which detention is being sought. And it really reflects the fact that this is a state law being implemented by independently, separately elected state's attorneys in each of the 102 counties. So this is what percent of cases had detention sought. The other thing that we looked at is what percent of the times are prosecutors successful? And I'll put success in air quotes because it depends on your perspective of what success means. But what this is measuring is when detention hearings were held, what percent of the time was detention imposed by the judge? Across Illinois, the success rate is around 60%, meaning that when a detention hearing is held, 60% of the time statewide, the defendant was actually detained. What you can see here is there's a lot of variation, again, in what percent of people who are having a detention petition or detention hearing held are actually detained. The important thing is these counties are sorted exactly the same as these. And what's intended to illustrate is the counties that sought detention a lot were not necessarily counties that had more success in these hearings, right? And so part of what we have to recognize is, again, once the case gets into a detention hearing and a judge is being presented with this evidence, there's a lot of variation in the decision about whether or not to detain. So not only does it reflect the discretion of the prosecutor as to whether or not they're going to seek detention, but it also reflects the judge's decision where they weigh the seriousness of the allegations, the risks for public safety, and what are appropriate alternatives when they make that decision to detain. The other thing that we wanted to spend a little bit of time talking about is what impact has this law had on the number of people held pretrial. And so when the law was being debated, one of the arguments for the law was there are a lot of people who are held in jail who have not yet been convicted of a crime, and they're being held because they can't afford bail, right? So some people's prediction was that this law would reduce the number of people in jail, or if it didn't reduce the number of people in jail, it would change the composition of who's in jail. Another one of the arguments that was made prior to the law is there can be people charged with very serious crimes, but if they have the money, they can post bond and get out. And through the elimination of cash bond, people that posed a risk to public safety could be held and couldn't buy their way out of jail. So when we look at what the impact has been, there's a few things that we want to point out. The first is if you look at the blue line on the chart, that's showing you how has the pretrial jail population in Illinois as a whole changed. And so what you can see is prior to the law, pretty consistently, there were right around 15,000 people on any given day in jail in Illinois in a pretrial status. After the Pretrial Fairness Act went into effect on September 18th of 2023, you see an immediate drop in the jail population. And then a fairly steady rate, and then it's gone up a bit in recent months. Simultaneous to the Pretrial Fairness Act going into effect was the creation of a new state agency in Illinois called the Office of Statewide Pretrial Services. And the important thing from the standpoint of our evaluation, but also the implementation of the Pretrial Fairness Act, was prior to the creation of the Office of Statewide Pretrial Services, the majority of counties in Illinois did not have any pretrial service capacity, meaning bail hearings were held without any kind of risk assessment. When the judge made a decision about bail, they had few options. They could release the person on their own recognizance, or they could impose cash bail. They could not release someone to supervision because that capacity did not exist. And so the Office of Statewide Pretrial Services was created and began providing pretrial supervision capacity in counties in Illinois in the spring of 2023. Importantly, the biggest impact of the Office of Statewide Pretrial Services was in Illinois' rural counties, which did not have any pretrial service capacity. So the jail population in Illinois as a whole has gone down, and when you look at the yellow line, that's the number of people on pretrial supervision. And so what you can see is the number of people on pretrial supervision began to rise when this office was created and actually created capacity to provide this. But then after the implementation of the Pretrial Fairness Act, it continued to go up in Illinois as a whole and reached more than 30,000 people by May. Right? The other thing that I want to point out with this slide that's important is, just like with the efforts at seeking detention and how it varied from county to county, the impact on jail populations also varies county to county. In Illinois' rural counties, there's been the largest drop in jail populations, and that drop has been sustained since the law went into effect. In some larger counties, the jail population fell, but has since increased, and in many instances has increased to a level that was higher than prior to the implementation of the law. Right? And so I'll turn it over to Don for the last segment of our presentation.
The other part of the law or the impact of the law that most people are concerned about is the impact on failures to appear and new charges filed against defendants who are released pretrial. Many of the opponents of the Pretrial Fairness Act argued that by releasing more people, failures to appear would go up, and by releasing people without requiring them to pay cash bail, failures to appear would go up. So we've looked at this now in 22 counties across the state, one large urban jurisdiction, and then 22 or 21 smaller rural jurisdictions. And what we're finding is that in those rural jurisdictions, we're seeing a drop in failures to appear within the first 6 months after a person is released. So the chart that you're seeing on the left is looking at failures to appear overall. And you can see in the one large urban county where we've looked at this, failures to appear went up from about 19% before the Pretrial Fairness Act went into effect to about 25% after the Pretrial Fairness Act. In a collection of about 21 rural counties, we actually see a decrease from about 25% before the Pretrial Fairness Act to 21% after the Pretrial Fairness Act. Again, this is looking at individuals who were released and who failed to appear for a court appearance within 6 months of that release. The chart you see on the right is failure to appear warrants that were issued. So this is when a judge finds that the failure to appear rises to a level that a warrant must be issued for the defendant. What you see in that large urban county is really no change in failure to appear warrants that were issued. It was about 10% before the Pretrial Fairness Act, and it was about 11% after the Pretrial Fairness Act. But you see a decrease, not just in failures to appear, but in failure to appear warrants being issued in those 21 other counties. A drop from about 17% before the Pretrial Fairness Act to 13% after the Pretrial Fairness Act. What we're seeing in looking at different groups of defendants and different ways that defendants came into the criminal justice system is two things. One, we're seeing that the failure to appear, the increase in failures to appear is largely around defendants who are charged with non-detainable felonies. So this would be class 4 drug offenses primarily, and then anybody charged with a class 1, 2, or 3 felony, those are serious felonies, that could only be detained for a willful flight consideration. So they weren't eligible to be detained for a public safety consideration. And what we're seeing among those populations, right, primarily non-detainable felonies, is an increase in failures to appear, both in this large urban county where we looked and in the 21 rural counties. In that urban county, it increased from a failure to appear rate increased from 21% to about 31%. And in those 21 smaller rural counties, it increased from 28% to 31%. What we don't have on here is also, we looked at how people came into the system. It's also individuals who were issued a citation rather than who were arrested. We see a large increase in failures to appear around that population too. And we're still trying to unpack why that might be happening, whether it's a misunderstanding about what the citation notice to appear means, or it's something else that it's affecting failures to appear. When we look with the same population of non-detainable felonies, we see some change in failure to appear warrants. In that large urban county, we see a slight increase. In the other rural counties, we see no real change in failure to appear warrants. The other thing we wanted to try to understand was new criminal activity. So whether defendants who were released pre-trial are being charged with new crimes, again, within 6 months of release. And what we see here is no real change in new criminal activity. This is limited to one large jurisdiction. What we see is new criminal activity largely unchanged, regardless of what defendants are charged with. So those who are charged with non-detainable misdemeanors, those who are charged with non-detainable felonies, the same group we looked at before for failure to appear, or those who are charged with detainable felonies under the felonies and misdemeanors under the Public Safety Act. For all of those groups, we see a stable rate of new criminal activity. For most groups, it's about 15%. For those who are charged with detainable misdemeanors and felonies, it's very low at about 8%. So what we're seeing is no real change in criminal activity and some change in failure to appear, but that seems to be fairly limited to certain groups of people charged with non-detainable felonies. And I'll turn it back over to Dave for some of the primary takeaways from what we've seen so far.
Thanks, Don. So findings is just going to be summarizing what we said, but a couple of the points we want to make sure folks leave with. First obvious thing is cash bail is no longer used. And prior to the law, there was a lot of discussion about the importance of cash bail and how it was important to motivate people to come to court. Since the law has gone into effect, we have not heard anybody say we should bring back cash bail. Really, the arguments now is we should widen the net of charges that are eligible for detention, but no one's saying we should bring back cash bail. The process and content of the hearings are being implemented as we expected, right? They're more substantive, defendants are being represented, but the actual implementation and seeking detention and detention being imposed is varying from county to county, right? Which really reflects the local nature of these decisions. Generally, jail populations have gone down and pretrial supervision populations have gone up. But we say that this is evolving because every month or every quarter when we update data, we start to see some different trends. The most recent period of time that we looked at through May of this year, as I pointed out, indicates that some county jail populations are now higher than they were prior to the law. All right. Don kind of talked about the increasing rates of FTAs for some categories, decreasing for others. So some of this starts to get complicated, but part of it is also the need to unpack the meaning and interpretation of those findings. The last thing we want to at least emphasize is how important the provision of state resources or state support for aspects of the pretrial process have been. We mentioned pretrial supervision through the Office of Statewide Pretrial Services as being something that we've seen as critically important in the implementation of this. From stakeholders we've talked to, they've recognized the importance of that being an option. And some of the patterns that Don found where rates of failure to appear decreased in rural counties for certain groups of defendants could be an indication that prior to not only the Pretrial Fairness Act, but prior to the Office of Statewide Pretrial Services, there was no ability for a judge to order someone to be supervised or for that agency to provide court reminders and assistance in getting to court. So some of those things start to come together. The other thing that Don mentioned is the state Supreme Court appropriated $10 million to provide for indigent defense services in Illinois counties outside of Cook. The year before the law went into effect, those public defense agencies were spending around $60 million. So that $10 million wasn't enough, most people would argue, but it was a fairly substantial investment. So we think that also was critical to assisting in the implementation of the law in rural counties. For those of you who are interested in kind of following our work, I'll just leave this up on the screen for a second. If you want to click on the QR code and go to our website, you can sign up for our newsletter. We put out a newsletter every quarter, updating emerging findings and new publications. So I think in the interest of time, I'll stop there and hopefully we've got some questions that we can answer.
Thank you both so much. I'm going to ask folks who are out there and who are in a position to do so to take a minute and turn on your cameras. Having done a lot of these, there's nothing worse once you've done your presentation than looking out into a bunch of solid black boxes that have the names of people you may or may not know. It's nice for our speakers to be able to engage with you directly. So give them the courtesy of including their names, your images, if you would. We have some questions in the chat that I'm going to get to, but I wanted to just ask a couple of clarifying questions just about procedure here. Am I correct that there's a 48-hour requirement for the hearings?
Yeah, there's a 40, it's required to be, the defendant's required to be brought before the judge within 48 hours for a felony.
Mhm. Okay.
And after that, if a detention hearing is going to be held, that has to be held within 48 hours.
A second 48 hours.
What we're observing is most of the time the detention hearing is being held at that first hearing. So it's not being dragged out for the full length of time. It's being done at that first appearance.
And then following up on a question that appeared in the chat, I'm going to reinterpret it. Let me ask, what's the standard of proof at the hearing, at the detention hearing?
I have that in my notes, but I couldn't see my
That's
notes when I
okay,
was
Dave. The
doing it.
reason
So
I'm
let me-
asking is because that's okay. The reason I'm asking is there was a question about how is this not turning into a mini trial? And for those of us who have defense backgrounds, mini trials are great. But I think in part that's going to be informed by just a procedural understanding of what the burden of proof is and whether there's a right to present witnesses. If y'all know, that might.
So the proof, the requirement is the proof is evident or the presumption great that the defendant has committed a detainable offense. Right. So that's the first prong. The second is that the defendant poses a specific, real and present threat to the safety of any person or the public. And then lastly, that the prosecution is to show that no other condition of release can adequately mitigate the risk.
Okay.
So in some respects, it is, to Don's point, these hearings are lasting 4 to 5 times longer than a bail hearing. There's a lot more discussion of the evidence as opposed to here's the charge, here's the bond amount we're recommending, and we're in and out in 2 to 3 minutes.
Yeah, we're seeing hearings on average lasting 15 to 20 minutes, with some of them lasting 45 minutes to an hour. And most of the discussion that we're seeing in those hearings is around the strength of the evidence. So a lot to that first prong of whether this defendant committed this act. So a lot of the discussion that we're seeing in the courtroom is around that. It then shifts when the judge has to then consider whether detention is the right outcome and no other lesser condition would meet the needs. Those then shift to be less about the strength of the evidence and more about the nature of the offense and other characteristics of the defendant. So, but that first prong really is taking up what we're seeing anyway. A lot
of the time.
Can I just throw in that what we're not seeing is testimony? So witnesses are not being called in these hearings.
Sorry, that's Patrick Woodfin, our Director of Communications, who's heading up our latest court observation project.
Well, that's wonderful because that was actually going to be the next question I asked. So I'll move on and ask a follow-up that picks up on a question in the chat that adds one of my own. Are y'all seeing changes in charge choices? In other words, in the volume of charges that are associated with detainable offenses? And so similarly, are you seeing an increased rate of declination? And I'm going to distinguish that here from dismissal, meaning cases that are declined before formal charging, as opposed to cases that are then charged and dismissed.
Right. I'll jump in, Dave, on the second part. We have no access to information about declination rates. Prosecutors have that data from themselves, and it's not in the court record. So we do have information on dismissal, so we're able to track case outcomes after filing. But if a decision is made not to file a case, we don't have any information about that in any of the counties where we're working right now.
Can you tell us a little bit about what you saw on dismissal rates? Because there's some interest in that question.
We haven't looked at dismissal rates yet. We wanted to make sure that this, right, because the law has only been in effect now. It's almost been 2 years. It'll be coming up on 2 years in September. We haven't looked at outcomes yet because we wanted to make sure we had enough time for cases to actually be resolved. And in some of the counties where we're working, time to disposition is incredibly long. So we wouldn't have had enough time until very recently to look at case outcomes in any meaningful way, at least for a large number of defendants. But that's something we're working on now through the fall for the final report for the project. But Dave, I don't know. We haven't seen a change in charging that although we haven't looked at it specifically that we've noticed.
Yeah, some of the longer term outcomes, I put a response in the chat. Our goal is to look at how this is affected, or if it's affecting case disposition, sentencing, those kinds of things. The caveat is getting data from 33 separate counties and processing that takes a bit of time. So
yeah, I know. So you will be shocked to hear that Jim Greiner has a question involving causal inference. And he is curious to know whether y'all had a chance to think about doing pre-post in other neighboring states.
Sure.
To lean, I think his expression was drifting, that would drift more towards drawing a causal inference.
We have a separate project that's looking at bail in 3 states. So we're going to use those other states to draw some causal conclusions about what's happening in Illinois.
I'm going to throw this over to Jim.
One of them
and
is
ask,
a neighboring state.
It is a neighboring state. So I'm going to throw it over to Jim and see if he has any follow-up on this, because I know this would be of interest not only to the research community, but to some of the folks who are partnering in that research work. Jim, is there anything you want to raise on this before I move on to some of the other questions?
Apologies for not being able to turn on the camera, but it's great news about the alternative states, because that just allows a little bit more elimination of national trends or things that were sort of going to happen anyway. So thanks very much.
Yeah, no worries.
yeah, and just one point to that is, as we mentioned, the law is being implemented differently in different counties in Illinois. So we're also able to look at that as how is an implementation that looks like this, where it's being sought often and imposed often, look differently than in jurisdictions where it's being sought less and detention's being imposed less.
So we're getting kind of 2 kinds of questions in the chat. Some are about the actual process itself, and some are about outcomes and analyses. And so I'm going to go back and focus a little bit on the process questions and then loop to results in that order. So for folks who are putting their questions in and wondering why I'm not taking them, I'm trying to organize it a little bit. On the process side, there were questions about, what's going on with the change in supervision, whether it's the intensity or the type of pretrial supervision that's happening. And I think I will add a little follow on that, which is I'm curious how that might be interacting with this I don't know if it's an anomaly, but this thing you're seeing where the FTA rates are showing one thing, right? And the warrant rates are remaining steady. I'm curious whether you think that is a result in part, or could be coming from the fact that there's something going on with the fact that there's pretrial supervision now that makes judges feel more comfortable about not issuing warrants, even though there's an FTA. I'm not sure, but if you guys could talk a little bit about the pretrial supervision, what's going on, how it's changed, there's some interest in that from the group.
Yeah, I think that's that's why these are good presentations, because you get ideas like that, like some of the stuff around FTA have to do with a pretrial service officer being told, hey, what's up with this person, right? And then being able to provide some insight into the ride isn't there, the car's broke, whatever it might be. Measuring the intensity of the supervision is not something that we've done at this point. When we present this, oftentimes people say, well, just because someone's on supervision doesn't mean it's requiring them to report frequently or what have you. And that varies from county to county. And there's some folks from the Office of Statewide Pretrial Services here, and I'll present my interpretation. They can correct me if I'm wrong, but from my understanding, for the people served by their office, the office determines the intensity or the level of supervision. So they do their risk assessment and they say, for this person, they require minimal reporting. For this person, they're going to require a higher level of reporting. In other counties, the judge makes that determination where they put the person on a certain supervision level, and that may or may not coincide with risk levels or any kind of risk assessment. So
Dave, I wonder, can you just talk a little bit about how many counties didn't have any pretrial service supervision before the Pretrial Fairness Act, and then a little bit about what you're seeing around the use of electronic monitoring too, because that might get to that question as well.
Yeah, I'm comfortable saying the majority of Illinois' 102 counties did not have pretrial. The exact number I don't know. So it was more than 50 did not have pretrial services before the law. One of the things we're finding about pretrial supervision being ordered and electronic monitoring being ordered is it's usually in cases where detention is sought, but detention is not imposed, right? So the state's attorney filed a petition, they held a hearing, the judge likely found there's sufficient evidence that the person committed the crime, that they may pose a risk to public safety, but they didn't reach that third conclusion that there's no other means to ensure public safety. So they don't detain, but they put them on pretrial supervision, or they order them to electronic monitoring. One of the things that's making it extremely interesting to study this is not only do things vary across counties, but things vary within the same county over time. So in Cook County, which is where Chicago is, there was an electronic monitoring program used for pretrial release that was run by the Cook County Sheriff's Office. Sworn deputies were the ones responsible for that. That program has been eliminated, and it has switched electronic monitoring over to the county's pretrial service agency that does not have arrest authority. And what we're seeing in Cook County is, since that change, detention is being sought more often and detention is being imposed more often. So again, for practitioners, they're looking at some of these options of supervision or electronic monitoring as the out for detention. And if those aren't seen as available or as trusted, they're going to opt for the detention.
And I guess I'll just flag again the phenomenon that Dave pointed out when we were looking at that chart that showed incarceration rates and supervision rates, right? You see this slight dip, a relatively modest dip in jail rates, in jail populations. You see a really steady increase in supervision because the supervision just wasn't possible before. I mean, I'm adding my own explanation of why, but it is certainly true that there was no one to do that supervision prior to the PFA. And what's we have some students who I know who are on this call. What's particularly interesting is that I think as a practitioner, you might worry a lot that the more people there are supervising you, the more it's likely that you're going to get violated and incarcerated, because often pretrial detention pretrial supervision is associated with conditions that result in people having technical violations for non-compliance. It does not seem like that's happening in Illinois. That's what the researchers are talking about when they say that the rate of judges issuing a warrant to go and bring someone back is remaining pretty steady.
Yeah.
Does that sound right, you guys?
The other important thing is the Office of Statewide Pretrial Services. Like I said, it was created in 2022. They were created from scratch and could basically say, what are the best practices? And we're gonna start off from that point. The other thing that's important is the law requires that if conditions of pretrial release are going to be included, like drug treatment or drug testing, there has to be a proven nexus in the hearing as to that behavior explaining the charges. So if you're charged with retail theft and they want you on pretrial supervision with drug testing or drug treatment, the prosecution has to show why drug use explains the criminal behavior. So there was
That's spectacular.
there were efforts at trying to rein in too much of a net widening and the inclusion of too many conditions that people could be tripped up on. And again, the Office of Statewide Pretrial Services, if they want to contribute at all, please do. But their experiences have been that electronic monitoring is not being overused like many were concerned for the cases that they're responsible for. And again, part of that involves education of the stakeholders as to what electronic monitoring does and does not do, but also letting them know that if someone violates their electronic monitoring, we're not going out and arresting people. We're going to let you know, and you're going to have to have a hearing and issue a warrant and go through that process. And so there's that the weighing of the pros and cons of that as well.
So anyone from the Illinois Pretrial Services Organization want to weigh in here before we move on? So then I'm going to just follow up with one other question.
I think there's just Cara took her
Sorry,
mic off.
I'd be happy to weigh in on anything related to the services we provide or what we're seeing if there's a specific question. But Dave, we are very fortunate to work closely with Dave and Don and Patrick, so they know our business.
Question for you, which is who's bearing the cost of the treatment? I mean, Dave talked a little bit about electronic monitoring costs and how they vary. who is paying for drug treatment, counseling, any of those kinds of conditions?
Everything that we do, and we serve 82 of Illinois' 102 counties, and we'll be at 84 in the next few months. Everything that we do is free to the defendant and free to the county. We make treatment referrals, but there's no cost to defendants for electronic monitoring, or if drug testing is ordered, we provide that at no cost to the defendant.
So can I ask then a follow-up question, and then I'll move on to some of the statistical questions people have. You mentioned at the beginning, y'all talked a little bit about the increased, the reduction in collection of income for counties, right? That once you're no longer taking a cut from the bond, there's going to be a net loss. It sounds like there's some room here to start hearing counties complaining about increased costs. Are y'all hearing that? And if so, do you have some sense of when there are any increased costs and reduction in income is being outweighed by the decrease in jail populations and jail costs?
Yeah, the way that I've decided to interpret it is counties are out a net $14 million. So before the law, they were collecting $14 million in these processing fees that they got to keep. Since the law went into effect, counties are getting $10 million a year for indigent defense services that they were not getting before. And they're getting the services of the Office of Statewide Pretrial Services. They're getting more in that respect after the law went into effect. The difference is they don't decide how the money gets spent.
Right.
Right.
They may not feel that way.
Yeah. And the issue with the jail populations is, I think a lot of advocates said, oh, we're going to save money if we reduce the jail populations. And part of it is they don't understand how jails are staffed and how budgets work, right?
Mm-hmm.
If your jail population goes down 10%, you don't reduce your workforce by 10%. Right. You don't do anything differently. You just have less crowd.
Fewer cheese sandwiches. Yeah.
Yeah.
I'll say this, so there is one thing, like the bail money that was collected before, that was used to pay restitution, fees, and fines. And the way it worked in most counties was if a person paid $1,000, that $1,000 was kept by the county, and it was then distributed for fees, fines, and restitution. That has changed, right? There's no longer that escrow account from which counties can draw from to pay down fees and fines. Clerks now have to go and collect that money from defendants. We haven't spent a lot of time talking to clerks about how that has impacted counties' abilities to collect, which is something to think about, right? Because if we add that into it, Dave's talking about a $14 million decrease in administrative fees that they collected, but there's $140 million in fees, fines, and restitution that also is not there, from which counties used to draw on to pay those. So it's one thing to think about, like how it might have affected clerks' ability to collect.
Mm-hmm.
Yeah. We're also, before the law, when we talked to stakeholders about bond amounts and bond being collected, there was some suggestion that the amount of the bond imposed was envisioning what the fees and fines and restitution likely would be.
Mm-hmm.
And when the case is disposed and the judge is entering the sentencing orders, there's the potential that what they said is the fees and fines and restitution is based on what they know is sitting in the clerk's office. So we are going to try to tease out, does this seem to have changed the imposition of financial conditions on those convicted, and how much of that is potentially because they recognize that getting the money from the defendant after conviction is different than getting money that the family put up prior to conviction.
Right. Yeah, that's fascinating. I'm looking forward to seeing what y'all learn about that. So there have been a whole series of questions in the chat about thinking about racial disparities in bail settings and bail amounts, pre and post PFA. Have y'all had a chance to do any analysis of that? And if so, what are you seeing?
Yeah, Dave, you want to talk about the OSPS data on?
Yeah, so we've looked a little bit at the role of demographic characteristics in the setting of bond and in the decisions in the detention of the defendants. What we have found is bond amounts ordered did not seem to be different based on the race of the defendant. Ability to pay that, this is in a separate study we did, found that race mattered, right? So bonds were equal for whites and blacks, but what was clearly not being taken into consideration in this study we did in a specific jurisdiction was ability to pay, right?
Okay.
Since the law went into effect, the decision to detain under the Pretrial Fairness Act, we don't see any differences between whites and blacks. We don't see any differences across age. We do see some differences with defendant sex, with males being more likely to be detained than females. And again, only of people eligible for detention and controlling for criminal history and the nature of the charge, things like that. We've done a little digging into the racial composition of jails in Cook County, which is the largest county in the state. The racial composition of the jail hasn't changed. Shortly after the law, the jail population was smaller, but the racial composition was the same. As of yesterday, the Cook County jail population is higher than it's been since early 2022. And the racial composition hasn't changed. So that just illustrates, to some degree how the impact, particularly on jails, is evolving as the law gets implemented.
Yeah, I'll
Did
just-
Illinois have bail
Sorry.
schedules before the Pretrial Fairness Act? Were there jurisdictions within Illinois that had bail schedules?
From my understanding, the only bail schedules that existed were for people who were charged with misdemeanor offenses other than domestic battery, where they could post bond at their arrest. There was a bail schedule there. When someone got into court and appeared before a judge, someone correct me if I'm wrong, but I don't think there were bail schedules. And if there were, all they did was set a fairly high maximum, but not specific to, within, $5,000 to $10,000 for this level crime, 10 to 15 for this level crime. So.
And I just want to follow up because the question in the chat was about not just racial disparity, but composition of the jail. So
Yes,
Dave
absolutely.
said the Cook County jail, right, the racial differences are the same as they were before. We are seeing a change in the composition of the jail, though. What we would call a hardening of the jail. An increasing proportion of the jail population consists of people charged with violent crimes, person crimes, and weapons offenses. And that's becoming the largest portion of the jail. And we're seeing a change in the composition of the jail around how long people have been there. So a pretty large increase in people who've been there 6 months or longer. And that population is increasing dramatically. And that's right, because people cannot bail themselves out anymore. We're seeing a compounding effect or a stacking effect of individuals coming in and then not being able to leave. And with long times to disposition, right, that population keeps growing. So the composition of the jail is changing, at least in Cook County. The people who are there are charged with more serious crimes, and they've been there quite a long time relative to.
And Don, if I recall correctly, what you said is what you're not seeing generally is a group of people who are detained for that 4-day period. In other words, one could have imagined that as a result of this, you'd have a group of people who were staying in for 48 hours, a group of people who were staying in for whatever, 96 hours, and then these long-termers. And what you're really seeing is short and then the stacking of these long terms. Is that right?
Yeah, the number of people on any given day, the number of people in the Cook County jail who've been there 4 days or less has always been pretty small because there's a cycle.
But I mean, statewide. Is that true?
Outside of Cook County, we have less information about the composition of the jail in that sense and how long they've been there.
Okay.
Yeah, a lot of the drops in the jail populations that we're seeing is just shorter lengths of stay, right? It's those people at the low end that used to say 3, now they're saying 1, or they used to say 4, now they're being released after they're identified. That's where most of the change is occurring. And
I understand from what you've said that that there are no longer bail schedules that allow you to get out before your initial appearance, right? So everybody, is that correct?
Well, the way the law is written is if you are charged with a crime that's not detainable, that the police have discretion to release you with a notice to appear. The degree to which that discretion is being exercised varies from jurisdiction to jurisdiction. In some jurisdictions, we've observed they hold everybody, they bring everybody before a judge, and then the judge lets them go. But they stay for 48 hours before that happens. In other counties, their interpretation has been if you're charged with a non-detainable offense, we have to just let you go. And so they arrest you, they process you through the jail to identify you, and then they let you out. And you spend 0 days in jail. For a detainable charge, the law says that you have to be brought before a judge to make a decision.
I know y'all planning to analyze, I would say, y'all planning to look at that, at where those decisions are being made and how, in terms of not on the non-detainable people.
Yeah, I mean, we're not seeing them come before judges. So, and I'll say this varies too, because outside of Cook County, in the places that we've looked at, they're still relying on arrest, even for non-detainable cases, and they're bringing people in to be fingerprinted and things like that. In Cook County, we're seeing a large increase in the use of notices to appear, so that people aren't being arrested and brought in, but rather they're being issued a citation or notice to appear at the incident. And then, so we're seeing some variation in that too. And there's been a large increase in the use of citations in Cook County.
Mm-hmm. Do y'all have any information as well about the number of cases in which lawyers are appealing to higher courts on the outcomes of these detainable cases? Dave's laughing, so maybe.
Shortly after the law was implemented, there was an enormous increase. I think Cara from the Office of Statewide Pretrial Services might actually have numbers. I think she looked at how many times was the bail amount challenged in the 30 or 40 years prior to the PFA, and then in the week after it, how many were filed?
Yeah, in the 10 years prior to the PFA taking effect, there were a total statewide in that 10-year period of 171 bail decisions appealed. And that was when the Illinois statute directed that bail, that cash should be set as a last resort, and that cash may not, the amount of cash bond set shall not be oppressive. And yet we had hundreds and hundreds of people, thousands of people sitting in jail on cash bonds that they could not afford, and yet there were just no appeals filed. So in the first few, and I can email Dave and Don, and they can share with you, in the first few weeks after the PFA went into effect, there were hundreds and hundreds and hundreds of PFA appeals, poorly done, oftentimes just not enough facts, not enough evidence, sometimes even photocopied and submitted as this sort of expedited appeal. So in response to that, the Supreme Court convened a task force that looked at the rules and made some modifications, and most importantly, that the appealing party had to go back and give the trial court judge an opportunity to fix it. They had to articulate to that judge what they got wrong, and whether it was because that required additional work, or whatever the case may be, the appeal numbers plummeted, and they're down 85, 88% over what they were in the first few months following the effective date of the act.
So can I ask a follow-up question to any of the three of you, I guess, or anybody else who has direct experience with this? Seems to me there are lessons to be learned from this about how system actors respond to additional burdens of work, right? That when the amount of work required of you to do certain things increases, perhaps you're less inclined to do that thing, and or perhaps you'll change your decisions. Do y'all have a sense of how that, whether that's correct and how that might be working here?
I can jump. I think what we've heard from interviews with prosecutors across the state is the burden is much higher now to detain somebody. I don't mean the evidentiary burden, but the burden of filing the petition and bringing evidence is higher, and that those decisions are, right, they're being much more deliberative about which cases they want to file petitions on. In Cook County, there's a whole new set of attorneys whose sole job is to determine, before things get to court, which ones they're going to seek detention on. So they've actually instituted new practices and a new set of attorneys whose job is just to review, to send cases on. So I think, yeah, I mean, the burden is real, particularly in those smaller jurisdictions where there is only, where the elected prosecutor is the only prosecutor, or there's the elected prosecutor and 2 assistants, and they're making very tough decisions about when to seek detention or not, because it does require a lot more time and consideration. Dave, sorry.
Yeah, and there were also some state's attorneys before the law went into effect that basically said, we will file on every case. We're going to seek detention on every case. And then I believe from knowing them that they were serious about it. And then I think they realized there's no way we can do this. They still had higher rates of detention being sought, but it was more like, half the time or 2/3, not 100% of the time. I think the other thing is, as the law, as implementation evolves, stakeholders got a better feel for what was involved. And, in some jurisdictions, we've talked to the stakeholders, and there's only one judge that has these hearings, and they know what that judge is looking for. And so the state's attorney's gotten to the point where we know what we think is a likely case. We're not going to waste our time or the court's time on these. And there's also just a realistic limit. In some of the counties, they have these hearings 6 days a week. There's only so many cases they can get through. And I know early on, and it still might be the case in Chicago, is these hearings go till 6 or 7 at night. And the assistant state's attorneys and assistant public defenders are getting frustrated that they're having to work till 6 or 7 at night. And so I think eventually it starts to kind of set its own standards of what we can handle, that kind of thing.
Yeah, it sounds like you've got some of this kind of courtroom work groups are changing their expectations about what's going to be acceptable behavior, and things are normalizing there.
Yeah.
And I'll just add that in the counties that we serve, whether it's a tiny rural county or some of the larger counties like Will County, which is where Joliet, Illinois is, every single prosecutor and defense attorney and judge gets a very detailed bond report, a pretrial investigation on every single case where the person was lodged in jail prior to the first appearance. So that is we are hearing just a tremendous resource to them. It includes a complete and verified criminal history, a risk assessment score, social history, demographic information. So that is a useful tool in this process for all parties.
And Cara, are those reports are being put together before appointment or after?
Before. So we have a 24/7 operations center that are identifying newly lodged individuals around the clock. They're preparing those criminal histories, verifying them, and then pushing them out to the pretrial officers who come in the morning, go to the jail, interview the defendants, put all that information in. And we have some counties whose first appearance calls at 8:30 in the morning. So staff is starting around 6 a.m. and others where it's not till the middle of the afternoon. So it, as Dave and Don have said, implementation of the law has varied state to county to county.
So y'all have some questions in the chat, and I'll try and summarize because we're heading into our last 5 minutes. Political pushback, particularly, are you seeing it from a state prosecutors association? And I'll add, are you hearing noise from judges, from police who may feel that their arrest choices are being shaped, or at least their charging submission choices are being shaped by any of this? Are you hearing complaints, feedback, pushback?
I think the way I'll describe it is, yes, there's still pushback, right? Like I said earlier, it's not we need to bring back cash bail. It's we need to be able to detain more people. You shouldn't have this narrow restriction. Some say we should be able to detain anybody if we can articulate that they're a danger to public safety. The other barometer that we use is the willingness of those who we are trying to interview to talk about the law has been a challenge. That for many, they're not interested in talking about it. They're not interested in being interviewed as part of the evaluation, and we sense from that they're not happy with it and that. So, but the one striking thing that we've haven't heard and that we mentioned is no one's talking about bringing back money.
And Dave, just following up, have you found that in your ability to observe what's going on in court, have you found that particularly in smaller jurisdictions, you're being shut out by people taking things into chambers because they don't want to let you hear? Or are you able to get still some good observation time in?
The challenge in the rural jurisdictions is there's just not many hearings. Right. I think we have a number in something that we did, but I think like probably a third of the counties have fewer than one a week. We traveled to a county in Southern Illinois in a rural jurisdiction, and They said, come on a Monday, we'll have hearings on a
That's right.
Monday.
Yeah.
So we drove down
Yeah.
Sunday, we got there and we're told, oh, we don't have any today. And so
Yeah,
fortunately, one of our colleagues at the Office of Statewide Pretrial Services said, well, go over to this county next door. They've always got a lot, right? And the benefit of that, in all seriousness, was we went to that other county, which isn't a project site, but we were struck by how many defendants there were. And that's when we were informed that nobody gets released through the cite and release. Everybody has to come before a judge. So they would bring defendants in the courtroom in mass, sit them in the jury box, and the judge would articulate to them the standard conditions of release. Don't commit crime. Let us know if you change address, show up to court, and then they'd be let go. But they stayed in jail for the weekend for that hearing.
And I will mention they all came in orange jumpsuits and shackled at their hands and ankles, knowing that they couldn't be detained. The court knowing that they couldn't be detained.
Which is, yeah, we see something similar in other places, non-jailable misdemeanors, for example, where people are routinely arrested and detained. Well, this has been fascinating. We are 2 minutes away, and yes, Sharice, the process is the punishment. We are 2 minutes away from being done. So I want to take a minute to ask, Dave, if you want to put that slide back up that had your QR code, so anyone who didn't get a chance to grab it the first time, we can direct them back towards your website and the amazing work you're doing. For folks who came in a little bit late, let me just reiterate that this is ongoing work. We heard about that at the beginning. This is, I think, how much longer y'all anticipate doing just this phase?
Hopefully a year and a half.
Okay. And I had, again, the opportunity to see some other slides that broke out rural and urban at some other conferences. This is an amazing project. QR code will take you to where you can get more information about this work. And we are all looking forward to learning more as it comes out. So thank you both so very much.
Awesome.
And thank you all for joining us.
Everybody.
If you will, Divya, if you could do us a favor and drop the link in for our next CJR talk, if it's available and handy. Otherwise, we'll look forward to seeing y'all soon. Again, for those of you who are writing, whether it's on the research side or the law review side, if you have an interest in presenting your work and getting some community feedback, please do let us know. We're happy to host you and look forward to hearing from you. Thank you all so much.
Great. Thank you.
Thanks. Bye-bye.